Welcome back, ladies and gentlemen, to Layman's Law School, where in this case, two Southern gentlemen lawyers talk about the legal issues of the day and hopefully in terms that you can actually understand. Today, we're going to be talking about an issue that is on the tip of everyone's tongue that I've talked to recently, and that is tort reform.
I don't know about everybody's tongue, but certainly people in the legal community that we talk to on a regular basis. But we're going to give you some information on what tort reform is, what different places across America are trying to do, specifically now here in Georgia, where we practice. And how it can make a difference, to you, what the impact of it is really to everyday Georgians and Americans.
Yeah, and I'm bringing this up in part because we need as much help as we possibly can. Citizens out there actually calling their representatives to basically influence them to not put in place what we believe to be some things that are just there to help large corporations.
Sure, because the only people calling right now are insurance companies calling, and their lobbyists calling all the representatives saying that this is what we need for business.
Yeah. This is when you're talking about special interest groups. Sometimes you can be considered to be a bad word. Trial lawyers would be a special interest group. The insurance companies would be a special interest group. I'm going to go ahead and let you know the insurance companies make $2.4 trillion a year in profit. So we hadn't hit numbers.
I'm not there yet.
Yeah, we hadn't quite got numbers up there, so we cannot really compete.
We haven't gotten 2.4 anything.
Yeah. Well, this is a David and Goliath type thing, but we are definitely fighting on the side of citizens. Our interests align. But basically, guys, tort reform is a way in which to somehow change the laws that involve car accidents, slip and fall, medical malpractice, these lawsuits that occur, right, to somehow limit the exposure to insurance companies one way or the other to having to pay larger verdicts.
Sure, and it's all about, most of these things have to do with, with negligence. We have a legal system where if someone is negligent and they cause you some type of harm, then you have the way that you can address that is by, either filing a claim with that person's insurance company that has insurance that covers that type of activity, or filing a lawsuit against that individual with the insurance backing it up. And tort reform is trying to limit the liability of insurance companies for various types of things, or limit the exposure at least of what they have to pay for certain things.
Sure. And I want the people out there to know that when you see a lawsuit out there and it says James Smith versus Don Johnson or whatever, all right, almost in every single case, 99.9%, the people paying the bill and the people that actually have to pay the damages are going to be an insurance company that's backing that person or that business or that car and driver. Right, and so they're the ones that are fighting to have these things changed. And currently, one of the things that they're trying to fight is in cases in where there's a commercial carrier, like 18-wheeler. Right now in Georgia, you're allowed to basically sue the person that was driving, which you never actually go after their assets or anything like that. You're going after the insurance associated with the truck. The business, the person that's employing that person, and you can be from all kinds of different reasons. Maybe that person had a bad driving history. They knew he'd gotten a couple of DUIs, but they let him drive anyway. Couldn't see
retention,
all that
supervision,
stuff. Right?
Absolutely.
But right now we're also allowed to directly sue the insurance carrier. So we name the insurance carrier in the lawsuit, and what that basically has the effect of is the jury knows that an insurance company is actually paying, and it's not poor,
John Smith, the poor truck
driver, right? That's got 3 kids. That this person, that person is now paraplegic, right? But he's got 4 kids and he's got to earn a living. How can we make him pay $1 million? But then when they hear, it's nationwide,
sure,
that they got deep pockets. Let's make sure we take care of this person that's been badly injured, and
that's really the only type case that we're allowed to
do that
that the jury is allowed to know that there's insurance available.
Yeah.
We're telling you, the general public, that the large majority of cases, if filed against an individual, they're filed because an attorney has already done the investigation, determined that there is insurance available. We always talk about, the three leg stool. You have to have a cause of action, you have to have actual damages, and then you have to have somebody with the ability to pay. Well, if you had a person that had no insurance that caused significant damages against another person, and the investigation revealed this person has no assets, no insurance, it would be, case closed. Everything's over. Because we're not going to spend time, money, and resources to pursue a case and try and recover nothing for our client. We're just going to have that conversation that there's nothing available.
Right.
But in cases where you do find that people have properly insured themselves against these type of damages, that's what we're actually pursuing. Is the lawsuit may say Shawn Merzlak versus Chace Hawk, but we're not actually trying to take the money out of Chase's 401k account or retirement, or make it so that him and his wife are not able to eat. We just know that Chace Hawk has insurance, and he has insurance that he has been paying to insure him against this type of injury. And we're trying to get some insurance proceeds to compensate our clients for their losses.
Yeah, and in that particular case, if you have an 18-wheeler accident, it's going all the way to a trial. In most cases, those damages, what's happened to that person is really significant.
Sure, absolutely. We're talking about a commercial carrier, a tractor trailer that is far different from a
regular accident.
A Toyota Corolla that hit you. It's far larger. It's a company that's engaged in making money off transporting cargo throughout the United States, and it's a huge vehicle, and it's a huge responsibility for the driver as well as the company, as well as the insurance company that insures them to make sure that they're operating safely. Right,
and I think that direct action, one of the ways it affects and protects actual drivers, everyday average Joes, is that because that regulatory or that direct action is there, the damages are very likely to be much higher, and therefore the actual constraints, the regulations, the amount of supervision that occurs for drivers in Georgia, right, is far superior to many other states, because otherwise they can just say, oh yeah, we don't have to worry about it because we're not going to get sued for that much. And so it benefits people in that particular way.
And that's all the goal of is to they allow this to go with a direct action against the insurer, so that it increases the safe operation of vehicles of people that are operating in the state of Georgia. So it's a great benefit to all citizens in Georgia and people that travel throughout Georgia.
One of the other things that they're pushing for, and this is kind of a little bit shocking to me or whatever, is that they're trying to cap non-economic damages. Can you explain to the viewers what non-economic damages are?
Sure. Well, we have, many damages that come with someone being injured from someone else's, negligence or number one, we have, the actual physical bills for medical services, things like that. Non-economic damages are things that you can't produce a bill for. I'm struck, from behind by a huge 18-wheeler, and I have some medical bills, but my back ends up hurting for the next, 15, 20 years of my life. I have significant injuries that either require surgery, or the doctors say you can have surgery or you can live with it. I don't know if surgery is going to actually help, so you might just have to live with this pain. So there's, loss of quality of life. A lot of people call it pain and suffering. Things that you miss out with. I have a almost 11-month-old son now. I couldn't imagine, being involved in a motor vehicle collision or some type of accident where my back was injured to the point that when he came crawling over to me and pulled up on my knees, I couldn't reach down and pick him up because of my injuries. Those are things that we can't present. Well, here's my bills. Yeah. They need to be paid. Those are things that have to be compensated in some way because I've lost significantly as a result of that.
Right, and it's commonly referred to as pain and suffering. But with them attempting to cap them, all they're attempting to do is to make it easier for them to calculate the risks on their spreadsheets. Sure. Okay, and they're not considering the effect it has on real people, because while maybe $250,000 might be plenty for non-economic damages in pain and suffering, in the majority of cases, there are cases where you have a young father that is hit from behind, and now he is in a wheelchair, and his young daughter, he will never be able to have the first dance with, walk her down the aisle. He'll be doing all that from a wheelchair. If he is a laborer, he's going to miss out on the, his job. He's going to have to go back through schooling. Everything he lost with the connection with his wife, the intimate relationship. Those are all things that have to be considered in $250,000 versus the rest of your life. That will not do it. And if they are successful in capping these non-economic damages, that person I just described, that young man, that will happen in the state of Georgia, and that person will be limited to $250,000 for their pain and suffering for the rest of their life.
And it's absolutely ridiculous. It's absolutely ridiculous that any member of the Georgia Congress or the Senate would vote for this. Because if you asked any one of them, regardless of their age, whether they're a young whippersnapper who's 32 years old and is, a new political person, or whether they're in their late 50s, early 60s, and you told them, I am going to injure you right now. I am going to pay all of your medical bills, but you're going to be paralyzed for the rest of your life, and I'm going to give you $250,000. Not one of those son of a bitches would say, okay, I'll take that deal. None of them would.
No.
And that's what they're failing to consider, and the large majority of people just think of tort reform,
out of control frivolous lawsuits.
Out of control frivolous lawsuits. We're not in the business of filing frivolous lawsuits because frivolous lawsuits would cost us money.
We'd most likely lose most of them.
And we would spend 2 or 3 years doing significant amount of work, spending money on depositions and expert witnesses and things like that, and in the end we'd get nothing. Our client would get nothing, and we'd be in the hole. And it's just not in contingency based litigation like most wrongful death, serious injury, personal injury cases like we're in. There is no advantage to us pursuing a frivolous lawsuit, and sometimes we have to be real with our clients and say, that's not what your case is worth. This is what your case is worth.
Yeah, and this is all sort of these ideas. It seems like well, what's the other side to this argument? I mean, how could you support any of this stuff based on the way we've described it? Well, it's basically described as helping businesses, insurance companies, to bring down, and then also bring down premiums for people paying insurance premiums. They want Georgia to be pro-business, and
we heard that before. I remember a very young, very spirited president that said, your health insurance premiums aren't going to go up. You're going to be able to keep your doctor. What happened? Can you believe, if ever, if there were tort reform laws placed into effect in Georgia or any other state, that Allstate, State Farm, any of these big insurance companies are going to turn around and mail to us, the consumer, a thing that says, thank God, tort reform passed, we're lowering your premiums.
Right.
No, the only thing that is going to happen is that insurance companies are going to make more money. They're already making plenty of it, and they want to make more, which is, I mean, I don't fault them for that, because they are a for-profit business, and that's the goal of a business, to maximize profit. I'm sure that I own portions of insurance companies throughout, mutual funds and retirement accounts and things like that. So, but there's got to be a happy medium, and I certainly think that what is going forward, or what is attempting to be pursued, injures Georgia citizens far more than it would ever help them.
Yeah, and I would appeal to people's common sense and their experience of reality when it comes to corporations. In the recent history, we have been told that inflation was due to the increased cost of oil and the tankers that were blocked in the canal and stuff like that. So we had to raise prices. Every corporation that I've basically looked at or a large number of corporations have had a huge boom in their bottom line. They have made record profits. Right, so
and when gas prices went down into the $2 range, they never lowered their prices.
The prices stayed exactly where they were, and in recent studies, this one coming out in 2002, that found that the insurance market seems, in important ways, to defy economic logic, because while caps and other caps on damages drive down insurance costs, and premiums do not fall in parallel with the costs. Instead, caps lead to sustained supernormal profits. Then there's another one by the Tampa Bay Times. Former defense lawyer, professor of California Western School of Law, gave a presentation in the National Association of Insurance Commissioners about how there's a huge lack of evidence for litigation having a material effect on the rising of premiums.
And this is a defense lawyer.
Lawyer.
This is not someone from me and Chace and Reid's side of the fence.
No, this is on the other side. Yeah, and he was speaking to the National Association of Insurance Commissioners. So he was talking to commissioners from every state, so they knew and understood that reducing litigation and the potential cost of litigation, putting caps on, does not have that material effect. In fact, the American Insurance Association says that the insurance industry never promised that tort reform would achieve specific premium savings. Sherman Joyce, president of the American Tort Reform Society, said, "We wouldn't tell you or anyone that the reason to pass tort reform would be to reduce insurance rates."
What's it for then?
Well, I don't think they're hiding the ball.
Exactly. It's so that the insurance companies make more money. That's all there is to it.
And they have a duty to their shareholders, but there has to, and this is one of my problems with our current capitalist system. Like, it is, they say it's a terrible form of government, democracy, right? But in the capitalist system, but it is just so happens to be the best thing that we have.
Sure.
Right. And to attack or to reform or to go after a particular area or a way in which we do things is not to attack the whole thing. And I think that considering corporations as people is a little bit problematic. I don't have a solution for it. But when you charge every single director of that corporation with a fiduciary duty to, above all else, increase profit, right? It usually comes, because there's a limit to how much you can charge people, it usually comes either in benefits to their workers, the salary of their workers, the quality of the actual product. That's usually who pays for all that. And when they can't pay them any less according to federal statute, okay, well then they cut the value or the quality of the product. And then if they still can't make enough money, they raise prices. And the insurance company, I don't think, are any different, but they are designed and driven. There's laws that make these people actually financially responsible if they make decisions that are contrary to that particular endeavor. And so it causes people not only to engage in the normal, self-interest of, hey, I'd like my bonus, right? I worked hard this year, and I worked hard my whole life to get in this position. Yeah, I want my $1 million bonus. But they are then also, by law, and beholden to their shareholders to make a decision that might negatively affect the population but benefit the insurance company.
Sure.
And so it makes it it's odd to me that we have a system in which integral parts of our society are almost required to make decisions that are not necessarily for the benefit of the whole. But that's part of our responsibility as trial lawyers to counterbalance that influence. Okay, they talk about how you have the special interest groups. Well, special interest groups compete. I remember when I first.
Well, and sometimes I think about it the same way as we might trial lawyers, plaintiff trial lawyers might be a special interest group, but we're a minority in terms of funding and breadth, and that's some of the things with that kind of defeats the capitalist market of insurance is just the barriers to entry to anybody getting into that type of thing. So there's very few insurers out there, and it would be difficult for me to start an insurance business.
Absolutely.
Even though I could probably do it if I was able to raise the
Capital.
significant amount of capital and charge rates that were lower than, Blue Cross or Allstate and State Farm and all these people. Well, then eventually in a capitalist market like we have, if I kept grinding, kept driving, more people would come to me. Shawn is charging less. He's providing the same service. Shawn is charging less. And eventually that would lower their rates. But because of it's such an industry that is so capital heavy to get involved in, there's very
few people that
could actually affect anything.
Yeah, and we are having another issue in our corporate environment that has never occurred, I don't think, in history. But if you look at the companies that are in the Fortune 500, the majority shareholders in those particular companies are two separate companies, Vanguard, BlackRock. And the idea that you go to the grocery store and you're choosing Oscar Mayer versus Hill Farms or whatever it is.
They own all of it anyway.
And so this idea that there's some sort of competitive driving down of price is eroding. And so we do not have a perfect system. America's a great place. Like I said, it's it might not be perfect, but it's the best we definitely have that I can see. But these two things I think need to be looked at, and that's that corporate structure and situations where you have stuff like this, where you have a corporation that is using vast resources to make policy decisions and laws that will definitely
harm consumers and just put more money in the insurance company's pockets.
Right. Not guarantee the savings that they purport to promise from passing these laws, and then it actually harming everyday citizens, not to mention trial lawyers.
I'm not even worried about me. I'm more worried about, like I said, the person that is 25 years old, gets in an automobile collision and gets paralyzed. Even if we're able to calculate their medical bills, and even if we're able to calculate future medical bills and take those into consideration, what person would say that it's fair to pay those things and just give this guy $250,000 to deal with that change in life, emotional crisis that he'll be in, for the rest of his life? Just things like that. That's the things that consumers need to be thinking about when they have the issue of tort reform brought up. Would you, if there's a cap on damages, would you trade your health and quality of life right now for $250,000? And if the answer is no, well then let the court systems, let juries decide what the appropriate damages are on a particular injury or a particular change in someone's life.
And the thing I kind of end on is like, when you're trying in a situation like this, when you're trying to figure out which side, you've got two special interest groups, trying to figure out which side is going to benefit you or tell you the truth on a particular issue, look at the side that your interests align with for the most part. Okay. In this particular case, we have an interest that definitely lies with the consumer, and so it directly ties to our livelihood, the livelihood of our staff, our business, but also the people that we see every day, because we don't necessarily represent people in California, New Mexico, or whatever. We represent people that live in the CSRA, and these are our friends, family, and we want them to be treated a certain way when it comes to the law, and that's what we're going to advocate for. So if you're hear about tort reform, know that it has to do with people being injured. And usually it has to do with insurance companies trying to limit how much money they might have to pay to injured people. It's a weird word. People don't like to hear, like tort. What's a tort? Tort reform, that sounds too highfalutin. It's about people being injured and insurance companies trying to limit their exposure. That's the easiest way to describe it. And you need to get involved in the political system. If you haven't already, call your congressman, call your representatives, and let them know, your state legislators, and let them know that you want them to look out for the interests of everyday citizens and not the insurance companies.
Absolutely.
So on that note, we'll end it. Thank y'all very much for joining us. We'll see you next time.